Oh, well. Good morning, everybody. We're just waiting a few more seconds for people to log on to this webinar about the debt collection process. Just give it a couple more seconds. All right. All right, Micah, if we can have that taken down. Cool, thank you. Well, welcome everybody to this month's webinar on the debt collection process. I have Josh Martin with me. I'm very fortunate to have him. Josh is the General Manager of New Zealand Collections, and he's been doing it for about 8 years, Josh, which is that's a good haul. TPS was founded in 2009 and has grown to be the largest and fastest growing tenancy-focused debt recovery company. They're actively working with over 700 property management and other industry offices, and they have an impeccable reputation with some of New Zealand's well-known and reputable businesses, and due to their focus on 3 key elements, and that's communication, transparency, and results. Now, before I get Josh to start, I just like to draw everyone's attention down to the question and answer button at the bottom of your screens. And please feel free, as Josh is doing his presentation, is to type in your questions and we'll take them at the end of the webinar. So once again, welcome Josh, and I'll hand over to you.
Thank you very much, David. And thanks everybody for having me. Some of you already may use our service or have done so in the past. So some of this information you may already know, but hopefully there are some things in this presentation that you can take away from it that you might not have known beforehand. And I guess your goal is to not have debts, but being property management, it is sometimes unavoidable, and it's good to know that there is a service here that can help recover that money for you. But just before I get into exactly what we do, I just wanted to highlight or bring up something that is happening at the Tenancy Tribunal, which a lot of people that I speak with aren't actually aware of or aware of the impact of it. And what that is name suppression at the Tenancy Tribunal. So where people are tenants are being granted name suppression where they often have caused a lot of damage to the property, and in a lot of these cases shouldn't apply. A lot of cases it should, but some where they haven't actually turned up to the hearing and might have disappeared, but still getting granted name suppression. So what I'll do, I've just got a little video here that it's pretty short, won't take too long, but just kind of highlights that and explains a bit more about what I was meaning. So I'll just put this on now.
It is time to bust another myth in the property management industry. If a tenant loses a tenancy tribunal order, they cannot have their name suppressed. It has become apparent that this is simply not the case. Since the name suppression law commenced in February, several tenants have had their identifying details suppressed, despite wholly losing their cases. So why is this? Let's take a look at the relevant section. In short, Section 95A outlines that the tribunal can suppress a party's identifying details if they apply to have their name suppressed and they have wholly or substantially succeeded in the order. But crucially, subsection 4 allows for the tenancy tribunal, on application or by its own initiative, to suppress any party's identifying details if it believes it is in the party's interest or in the public interest. Essentially, this means that the Tenancy Tribunal can suppress any tenant's details, no matter what the circumstances, and even if they don't ask. In a recent Tenancy Tribunal order, The tenant had their identifying details suppressed, despite having their periodic tenancy terminated for 3 antisocial incidents in 90 days under the new Section 55A. This antisocial behaviour included playing loud music, swearing, police attending for a domestic incident, and verbally assaulting a neighbour. The adjudicator wrote, "The landlord and tenant both sought name suppression. As the landlord was wholly successful in their claim, name suppression is granted. The tribunal also grants name suppression to the tenant so that their ability to secure future rental accommodation is not hindered by this order." In another recent tenancy tribunal order, the adjudicator suppressed the tenant's identifying details, despite the landlord being awarded nearly $3,000 for rubbish removal, garden work, and several intentional incidents of damage. This damage included holes in the walls in the bedroom, lounge, dining room, and hallway. The tenant did not attend the hearing, yet still had their details suppressed. Finally, in this tenancy tribunal order, a tenant had their name suppressed despite owing nearly $3,000 in rent arrears. While it's clear this myth has been busted, we must acknowledge that not all tenants are having their name suppressed when they lose a tenancy tribunal case. Some are and some aren't. But the examples we have highlighted prove that some tenants are very fortunate to receive name suppression. Landlords and property managers should have the right to know that applicant tenants have had previous tenancies terminated for antisocial behaviour, rent arrears, or racking up thousands of dollars in intentional damage. This law change clearly makes tenant vetting more difficult at a time when tenant selection is more important than ever before. If you have any feedback on this issue, please email media@tenancy.co.nz and we will present the responses to government asking for change.
So there's 3 examples where considerable amount of damage where the tenant shouldn't have necessarily been given name suppression, but they did, and in a lot of the cases they didn't actually turn up to the hearing. So what that means is that if their name isn't shown on the tribunal order, it's basically not going to show up on any type of register if you're doing a background check or a credit check. So it's not going to show on the tenancy tribunal. So in these particular cases, people, I guess the reasoning for the tribunal to do that is they don't want to affect them getting another tenancy, and you want people to have a place to live, but people should also be alerted to repeat offenders. And and if this is happening at the tribunal, that's basically not going to happen, and nothing's stopping the people just from going to property causing damage. So what is the solution? Basically, the first step is you can ask for an unsuppressed copy of the tribunal order at the time of the hearing. So even if they aren't putting the name on it, you can ask for the unsuppressed copy. Basically, if you need to enforce it through something like an attachment order, the courts need to see the name on the order in order to do that. So if there's nothing reading there, they don't know who to enforce it from, basically. And if it's past the date of the hearing, you can request it from the Ministry of Justice. They'll give it to you. And then that can be basically used to load on the debtor's credit file for enforcement purposes. And the way that you would load it on a file, in most cases that come through to us, is be loading it with a collection agency like us. Within 30 days, that gets loaded. So that's where, if you're doing a background check or a credit check, that person's going to show up and it's alerted to you, and then you'd hope that other property managers do the same for you, where it shows up. So I guess past that point, taking it back a step. So if you have a debt owing at the end of a tenancy, what is the next step? I often get that question. So we'd always recommend getting a tenancy tribunal to start with, to a tenancy tribunal order, because that'll give you more options in terms of enforcement if the tenants don't pay. It also means that if the tenants do turn up to the hearing and they are in correspondence with you, it means that there is a judgment amount where it's not disputed, basically, and then you can often, if it gets to that point, what's commonly happening, in an example, David had given me a couple of examples where a payment arrangement is actually listed on the tribunal order. So that's an ideal, and this is an example here of where they've listed that, weekly payments of $30. So that's ideal for you guys, where to get the debt paid to you directly, where you don't need to use a collection agency, you get the money. Ideally, you don't have to go to the tribunal, but often that's unavoidable and it gets to this point. So past that point, what happens if the tenants don't adhere to the order? On most orders, it basically says that there's an amount owed and that the debt is to be paid immediately, but that often doesn't happen. So basically your job should end at the tenancy tribunal. If the tenants have disappeared or if they're not cooperating, there isn't a charging provision for any collection service in your management agreement. So that by using a service like ours, that's where, being a debt collection company, we can add the cost to the debt, because you do have a clause in the tenancy service, but the TPS agreement, there is a debt collection clause allowing for that. Past that, trying to recover a debt, it's just very time consuming and it can be a tedious process if you're trying to track a person down. Most people don't have access to certain databases where you can find information, and you're also bound by privacy. So you're best to use a specialist to do that for you if it's got to the point where you're not getting anywhere with collecting the debt. So that's where we come in. So our basic service is that we've been a specialist in collecting tenancy debt for over 15 years. So we know how the court system works, and to be able to track the debtor down and to be able to get the debt paid off as quickly as possible, where possible. There's no cost to lodge a debt, and our fee is charged on any money we collect from the tenant. So that means no upfront cost to you, and it's based on the result that we get. So the only way we get anything out of collecting the debt is if the debt is paying. So, and then after that point, if we do get the debt paid, we pay you out quarterly. So we'll pay you out what we've collected in the 3 months prior, less that 20% plus GST. And then we'll also, if you need to enforce it through the district court, so past a tribunal order, we need an attachment order, we'll cover the cost of enforcement to do that. To do that yourself, you can apply through the district court directly, which a lot of you will know. There's a $50 fee through the courts, which I think they've just put that up slightly. We have to go through a lawyer to get that signed off, being a third party. So for us, it costs $200. So we're putting our own money in to get it collected. So it's not only our time, it's our money that we want to get back. So we've got just as much incentive as you to get the debt collected. So it's a bit of a two-way stream. And yeah, lastly, it means that there's no upfront cost to you or the owner, and it frees you up to focus on the profitable tenancies. So the key information that we work from once a debt is loaded is basically all the information you have on the tenancy agreement. And at this point, if you are loading it, it's really important to include as much information as you possibly have, because it just speeds up the process and increases the likelihood of actually collecting the debt. So things like a date of birth is important. If you have that, full names, a lot of people use different aliases often to try and not avoid showing up on a credit check. So if you know them, include those. Emergency contacts and references, really important as well, because that's often how a debt gets paid. Someone who owes money might be changing phone numbers quite a lot, whereas an emergency contact may not. And so yeah, still include those and try and get those at the time when somebody's signing on. And then lastly, a source of income is really useful information if you get to this point. You can't ask that on a tenancy application, or on the agreement, but you can ask for a proof of income. So that's often you sometimes might know, or just having dealt with the debtors directly, the tenants directly. So once it comes through to us, our first step is to try and come to a voluntary arrangement with the tenant, and that's done through a direct debit. So as opposed to an automatic payment, the person's set up for the full amount of the debt on a weekly or fortnightly arrangement where it's through their bank account. So it's not an automatic payment where they pay whenever they want. They're committing to a payment plan, and then we can monitor those payments. And if there are any defaults, that's when we can try and correct the issue. So that's always our first step, because at this point, the debtor, we can add the collection costs to the top of the debt that the debtor pays. So it means that if the debtor pays in full, you're receiving the majority of the original debt amount back. And it also means that it speeds the process up, because if we have to go to enforcement through an attachment order, that means you're having to file through the district court, and then you're waiting for that to be processed. And it can sometimes take a long time if they start at all, basically. And then it means the owner gets paid out quicker. And then if that can't happen, the next step, if they're basically disappeared, or they're just saying they don't want to pay, they don't agree with it, the next step is an attachment order. Again, a lot of you would already know this and have done it before, but some don't. So attachment order, basically, it's where it's enforced directly from the debtor's income source via the district court. So you first need to have a tenancy tribunal order in order to file for that. So what happens is that if you have the correct information, the person's source of income, and you have their full name, date of birth, then you can file it through the district court. And then if it is correct, the payments will start based on the person's income. So if somebody is, say, for example, a WINS client, we process hundreds of these orders a week, and the courts never usually award more than $50 a week maximum. And it can be anywhere between $0 to $50. So the most common is $20 to $30, but just something to keep in mind. And then if somebody is employed, then it's usually, it's usually $100 that they'll award if they earn that much. If you're wanting more than that, then you have to prove the person's income. That can be difficult because it requires a bank statement, which you often might not have, but you might have it. You can also apply for a financial means test, which it basically summons the person to court to provide all of their financial information, basically. But that requires the person actually cooperating and providing that information. In a lot of these cases, the tenants have disappeared where that can't happen. And then through an attachment order, the courts will only enforce the amount that is on a tenancy tribunal order plus any court filing fees. So that means that they don't add our collection costs to the top, 20%. So that's why this is always the second step, where we get the majority of the debt paid off through an attachment order, and then that remaining amount of the collection costs we will still attempt to collect, but it has to be paid through a voluntary payment. So just again, the required information for an attachment order is a source of income, full name, and the date of birth. The source of income, again, can be difficult to find. So as much information you have at the start of the tenancy on that tenancy agreement or the application, it really helps. The next step past that point, and the real difficulty, is if you have filed for an attachment order before, it's quite common for them to stop and start for different reasons. And often that's because the person's income source has changed. And an attachment order won't automatically restart to the new source of income. You'd have to try and find that. And that's where it becomes difficult for just a normal person, especially for you guys. You're tied up with your day-to-day, focusing on property management. You don't have time to be searching through Facebook or the different databases. All of them you don't have access to. Or that's something that we can help with, and we're good at getting them restarted. And what that means is that we may need to do tracking on the file to find new information. And I'll go over what we do in terms of tracking a little bit further into this. And then if you do find the new information, the next step is applying for what's called a variation of the attachment order. So that's when you're using the existing attachment order and with the new information that you've found, and then they charge for that as well. So the common reasons why you'd need to do a vary would be, so as mentioned before, change of income source, an additional tribunal order has happened. So that's a really common one. There's an order for maybe vacated costs after the rent arrears. So you have to do a vary on an attachment order to add that order into it. And then another common one is, say if it's a WINS client, it's very common for people to go on a stand down period, and that's when the payments are going to stop. And then that's something that the recent changes that have happened through the government, where they're saying that they're going to be a lot harder on people who basically, if you're on a job seekers benefit, if you breach the terms of that, they're basically going to stop the payment. So that's going to affect debts basically. So people paying rent and even debts that have been loaded. So again, another reason why you'd use us is that we have a system where we track these files and then reapply for them where we need to. And this point here, the WINS stand down period is 3 months. So they say that if the person's on a stand down and their payments restart within the 3 months, they'll restart the payments. That often doesn't happen. So we then, at that point, if we think we have the right information, we'll reapply, and then that's how the payments start. So yeah, it's quite a painful process. So all the more reason to pass it on to a team that can do it for you. Couple of examples of where enforcement wouldn't work. So if somebody's a self-employed business person, basically an attachment order gets sent to the person's payroll department, and payroll make the payments. If you're self-employed, you're basically just sending it to that person, and it becomes a voluntary payment. So in a lot of cases that doesn't work. Non-New Zealand residents, so if the person's not living in the country or not earning money here, we can't enforce it on that person. And then the last part is, if somebody's unable to meet basic living costs, then the payments won't start. Quite a lot of debts that come through, if somebody is a WINS client, they might not be successful straight away. All of these situations here are just the current situation. So somebody if they've moved overseas, they may move back to the country. So there's still a reason to load a debt. And if you have loaded it, if the person's moved back, then it's going to affect their credit file basically. So if they're filing for new tenancies or credit, that's where it's going to show up, and that's where you potentially may get the debt collected. And same for people with the basic living costs, that their situation may change where they may be able to afford it. Then I guess the next step from there is what we actually do in terms of tracking the file. What can we do that a normal person wouldn't be able to do? So if we need more information about the debtor, we'll need to track it through the following sources basically. So an address trace through the Centrix Credit Bureau and other bureaus, where we often do find if people have applied for tenancies, that's where we commonly do find a new address and new information, and which leads to a payment plan. TPS background checking, searching the PPSR register, so personal properties and securities register. If people are putting things on finance or credit, that's where they often do provide new information at that time. Could just be a matter of finding a new phone number where the first time we're able to speak to someone, they actually set up a payment arrangement. That often does happen. Credit checking, and then just something as simple as social media and Google results, which anybody can do, but it's depends when you do the search, and it's time as well. You guys don't have time to be searching through Facebook all day. And that's often where you might find something like a workplace through social media. So that's basically how it works. the key message there is to supply as much information as you possibly can really speeds the process up, and it means that if we don't need to track the file, that can result in the debt being paid off quicker. It could be the difference. I guess the next point I wanted to bring up as well, and a lot of people I speak with don't realize this, is that in order to get a lot of people basically delays through the tribunal and actually getting a hearing, and then also being able to find an address for service to take to the tribunal. So you don't actually have to lodge a debt with us. You don't need to necessarily have an order. A lot of people do load a debt with us to actually try and find a new address to take to the tribunal. So that's a service that we can help with. But something that has come up is basically there was a case recently with a client that I met with where it was after the 8-week period where you can use basically an email address, and they needed to find a new address to get a tribunal order. Basically, under section 91A of the RTA, that limits the landlord's ability to file an application to 8 weeks after the termination date of the tenancy. After this period, the landlord must satisfy tenancy services that they'll be able to serve the application on the tenant in one of the following ways. So a lot of people that I speak to, it depends on the adjudicator that you get and what they actually say, but this is what it says in the RTA. So it needs to be served either personally by posting it to a contact address that the tenant has supplied in writing within 2 months before the application, by delivering it to the place where the tenant now lives and giving it to anyone appearing to be aged over 16 years or older who appears to be residing in that place and who confirms the tenant is living there, or by giving it to any solicitor or other agent of the tenant duly authorised by the tenant to receive service on his or her behalf. So the first three there, if the person has disappeared, you're not going to be able to do this. So getting an address for service to actually take to the tribunal becomes difficult. But this last point here regarding a duly authorised agent by the tenant, this is something that is actually part of the TPS agreement. There is a section in the emergency contact field that covers the duly authorised agent. So there was a case recently where the landlord was able to claim rent arrears and damages by serving it to the father, who was the duly authorised agent. And this is where you'd find it on the agreement under the tenant details, emergency contact / duly authorised agent. This particular one was the uncle, but in that case it was the father, and you can actually serve it to that person. So another thing to keep in mind, that this can help you get a tribunal order a lot quicker. There's one person was actually waiting a year to try and find an address for someone where you could actually use that section right there. Another way is if that doesn't work, or if you didn't have that at the time, we may be able to find that. So we can do an address trace through the Centrix Credit Bureau, what I was mentioning before, and that's where we may be able to find a new address. The debt would just need to be lodged with us first before we can do that. Basically, we need to have a reason to be running a search, and if a debt's loaded with us, if it's for the purpose of taking to the tribunal, you can do that. So another thing to keep in mind, a lot of people that I speak with don't actually realise that. So we may be able to help you there with that. And then how you would load it is that you just load it with a rent ledger or an invoice, and then we can go from there and run the search. So I guess the next step is maybe just covering a little bit of how credit ratings actually work. So again, it's basic stuff, but you might, someone might not actually know, but a credit score, it's usually out of 1,000, and a score above 700 is considered good. So the time limits, a tenancy debt will remain on a debtor's credit history for 5 years from the default date, regardless of whether it's paid. So some of these cases where there are huge debts, there's 5 years sometimes isn't a huge amount of time, especially if somebody's moved overseas. So time's of the essence. In terms of collecting the debt or enforcing it, a debt's enforceable up to 6 years. And if you've had a payment within the final 12 months of that period, it just keeps going and extends the life of the debt. So just because it gets removed from the credit file, it still doesn't mean you can't enforce payments or collect the debt, basically. A default payment, so in order for it to be loaded against somebody's credit file, it has to be over $125 and then overdue for more than 30 days. And the lender would have had to have made efforts to recover the money. So in most cases that you would have before a debt gets loaded. And then 3 credit agencies in New Zealand are Centrix, Equifax, and Ilion. And then here's an example of how of a credit report that isn't great. So this particular person is insolvent. So it basically brings their score just right down to 0 in that particular case. And then you can see here, this person is using different variations of their name. This is really common. So often to try and avoid showing on a credit file, going to new tenancies. So this person is known as, or his name's Montgomery Mercury, where he's using his middle name at the start. We see lots where they completely changed their name. Some debtors that come through to us have got 7 different names that they go by. So and a lot of them are cases of identity fraud as well. And then down the side here just gives you an idea of the activity on this person's file. So a lot of file accesses, which indicates potentially putting a lot of things on finance. Not necessarily, but that can sometimes be the case. Total other names 4. That's a huge amount. Also credit defaults, that a lot of those there. And then obviously insolvency notices. So somebody's insolvent, that's going to bring it down, but just things to look out for. This person's known by a lot of different names, even date of births. That's a real red flag there. And then that's basically the end of the presentation. But I guess the key message there is, well, about what we do, is that the only way we receive any type of payment is if we're collecting the debt ourselves. So, and then we've often put our own money and time into collecting the debt. So we've got just as much incentive as you to get the debt paid in a timely manner. We've got a team of people that work on these debts. It's not just automated messages. We're constantly working through them. We'd never give up on a debt, but if a debt's not currently being paid, it'll be for a reason. And we periodically search these, do tracking on these files to try and find new information. And then our key is to just take that work away from you, where you can focus on the things that you do, and then we can hopefully get the money back for you. And our key is just to keep in communication, and then, yeah, I guess you can focus on the people that are actually paying. Right, well, that's David, that's sort of the end of the presentation. Were there any questions that people had?
Yes, yeah, there have been some questions, which is great. Don't have to have that pregnant pause between
Yeah,
the seminar and then trying to get people to ask some questions. But one I've got here is there a minimum amount you will accept for debt recovery?
Yeah, well, it's with the credit file, basically what it's covering on the credit file is that 125, we would accept that. Most debts, the average that come through to us is about $2,000, which, yeah, is a lot higher than the 100, but usually it's over 125 that we will collect. And then in most cases, you'd hope that you do get a tenancy tribunal order for it that can be enforced. Yeah. Okay,
cool. Another question is, does a tenant have to ask for name suppression to get awarded it? I think in the presentation, the adjudicator could be proactive, couldn't they? And
Yeah, well, that's the thing, is those cases that the tenants haven't even turned up to the hearing and they've disappeared, and the adjudicators just decided to give name suppression. So yeah, they don't have to ask for it. And yeah, which is quite strange. And there are lots of cases where somebody should get granted name suppression if it was something like domestic violence or something like that. But these are cases where there's actually just, there's no explanation for it. It's just so the tenant doesn't, it doesn't affect them applying for tenancies, but it's where people should be alerted to repeat offenders, I think.
Cool. Okay, another question is that does not having a date of birth dramatically affect your chances of collection?
Not necessarily. We can often find that through a centric search. If you're needing to enforce a debt, so through WINS, you have to have a date of birth, but you may get it paid voluntarily. If it's through a workplace, you might not need to have a date of birth if we're enforcing it. But it can be difficult to identify a person if there's a lot of people with the same name. If you're doing a credit check and there's different date of births, it might be hard to know who is the actual person. But you can often identify that if they were staying at the different tenancies that the debt is for, basically. I guess the answer there is it depends on who the person is that you're dealing with.
All right. This is a long question. So if you can't locate a person owing, how long can you keep trying? And does this debt stay on their credit file? And in 18 months' time, when they apply for finance, does it reactivate your search?
It is, yeah, no, that's a good question. That's a really common one as well. It's basically 5 years from the default date. So if you've got a tribunal order, it'll be 5 years from that date that it'll stay on somebody's credit file. But then it's enforceable up to 6 years. And then throughout that time, in the final 12 months of that 6 years, say if you've had no payments, but in that 6th year you get a payment through, it's then you can continue collecting the debt after that point. Unfortunately, some of these big debts where it gets removed from a credit file after 5 years that shouldn't happen. I don't think. And if you owed the government money, that's a different story. That would stay on your credit file, and if that would also affect you if you're at customs, if you're going overseas. But this particular kind of debt, yeah, it's 5 years basically. And then the second part of your question, if somebody's applied for finance or credit, we don't get alerted to it, but that if we do a search, that's when we will find it. So it doesn't necessarily just pop up when they apply for credit. We'd have to do the search to do that.
Okay. I think you might have addressed this in your presentation, but the next question is, are you able to do a credit check in order to find out the new address after the tenancy ends?
Yeah, well, that's just that. Yeah, the Centrix check is where we often do find an address. So if you don't have that, it's quite often you might not have that new address, or you will have the duly authorized agent, and that's where we can often find that. So you if you're needing that to get a tribunal order, we can help with that. So the debt would just need to be loaded with us first with, say, a rent ledger or an invoice, and then we can run this. That gives us a reason to run a search, and we might find a hit.
Okay. Another good question here. If the debt is from a landlord or an owner, is it the same procedure?
Yeah, it's exactly the same. It's we'd obviously prefer to deal with the property management companies directly, but we have a lot of clients who are landlords that can load it directly with us. So it's the same, basically, same process.
It's just from that, if you've got a bad owner and they owe you money as a property management company, would you have to go to the disputes tribunal and get an award there for it to activate it?
Yeah, you don't need to have an order, but if in order to enforce it, then you'd need yeah, you'd need to go to the disputes in that case. We do actually have a lot of debts that have been loaded for that particular reason. Yeah, an owner hasn't paid certain costs.
Okay, that's cool. And does the debt history in New Zealand affect the tenant's AU credit report?
At this point, it doesn't. That's something that's always it's been talked about for a long time, but at this point, it doesn't affect you in Australia. But there's always been lots of talks between the credit bureaus, joining forces, where if somebody's moving to Australia, that will affect you. So at this point, it doesn't, but it may not be long until it does, I think.
Well, Josh, it looks as if you've answered all the questions at the moment. If anyone has a burning question, I suppose they can always contact you at New Zealand Collections. Well, thank you for that very informative talk. I think everyone would have taken something from that presentation. Thank you so much for presenting for us.
Well, yeah, and thanks so much for the opportunity. And if anybody does have, say, if you want to talk individually, feel free to contact me. I send my details through, and happy to. I quite often do meet with individual officers as well if you have particular things that you want to talk about. So I'm here as a point of contact and to discuss anything further. We're keen to help with any debts that you might have.
Awesome. All right, thank you. And thank you everyone for participating. Go and have a great lunch. It's nearly lunchtime. And we'll catch you at the next RPA webinar. Do not forget, please, to make sure that you go onto the RPMA website and add your CPD point for this webinar. Yeah. All right. Goodbye, everybody. Thanks again, Josh.
Cheers. Thank you.